Hey guys. So here is vocabulary review for you for chapter 1, second set. That's what we're working on this week. And of course, you can see that I'm in Quizlet. And I shared, let me just click on our lesson plan really quick here. Nope, that's not the one. This is the one. I'm still working on this, but the link to this set is right here, and all you have to do is click it and it'll bring you right to where you need to be. So we're going to go through our words for this week. We scroll up here. There we go. So your first word is bail. Bail. And you probably have heard this word before. The textbook definition is usually a monetary guarantee deposited with the court to ensure that the suspects or defendants will appear at a later stage in the criminal justice process. So the textbook definition is being a little vague here. What are we talking about, a later stage in the criminal justice process? Well, we're talking about coming to court, coming back to court after you have been arrested and arraigned and charged, coming back later to either plead guilty or go to trial. Because that's really your two choices if the case doesn't get dismissed. And so there's a lot of controversy lately around bail. New York State in particular has done an entire bail reform. You may hear about that a little bit, where basically they have eliminated almost all bail requirements for most crimes. And so what that means is, you get arrested, even if it's for a felony, a very serious felony, you're just processed and let go, and you're right back out on the street. Bail is not a punishment. It was never meant as a punishment. It was simply meant as a way to make sure the person comes back to court when they're supposed to, because you get that money back. When you come back to court on the date that you're supposed to, whatever money you put up, you get that back. Because bail is not punishment. It's not a fine. Punishment comes after you are convicted. So bail was just a way to try to, make sure, because people want to get their money back, of course. So it's just a way to make sure people come back when they're supposed to. When you don't have to put any money up, you really don't have that much of an incentive to return. And so there's a lot of controversy around it. And the other thing is that in most other states, and it used to be this way here in New York, a judge could deny bail if he felt that you were a threat to the community, meaning if you got out, you were going to hurt more people before your next court date. And with our latest bail reform, a lot of that discretion was taken away from judges. So that's a really big topic for us here in New York State. But your first vocabulary word is bail. Your next few words really are connected to courts and court systems, and we're still in our law enforcement unit. So our words are jumping ahead a bit than from where we are. But basically, there are many checks and balances along the way in a criminal case to ensure that the defendant is given every right and every benefit possible. And I'll give you a number of examples. The first one, a criminal case starts with law enforcement, the police, right? The police have to believe that a crime was committed, and they have to have probable cause to arrest the defendant, the suspect. Probable cause, you learned last week, it's a very high level of proof. It isn't 100%. It's not absolute certainty, but it's a pretty high percentage that, yes, we have enough evidence to show this person did do this crime. That's probable cause. That's where we start. But after that, there are still many other processes and steps that have to happen in this criminal case before anybody ever gets convicted or punished. And so one of those steps is your next word, which is preliminary hearing. So the definition is, in a felony case, it is a pre-trial stage at which a judge determines whether there is probable cause. So let me back up for a minute, and we really haven't even talked about the prosecutor, the district attorney, who is also a lawyer. So a criminal case starts with the police, but the next place that case goes is the prosecutor's office, the district attorney's office. And the prosecutor looks at it and decides if they're going to continue prosecuting that case, or if they're going to prosecute that case. A prosecutor can decide right then and there, you know what, I know the police made an arrest, but we don't think there's enough here, or we don't think there's enough to get a conviction, and we're just going to toss it. They can dismiss charges. The police are only the beginning. There are many people after them that can throw cases out or dismiss cases or change charges, reduce charges. And the next step would be the district attorney's office, and they can do any of those things. They decide, and again, they're lawyers. They decide, yes, there is enough evidence here. There is probable cause to go forward with the prosecution of this case and this defendant. From there, it goes to a court, a judge, and that's where preliminary hearing comes in. So you have yet another lawyer, another office, separate from the police, separate from the district attorney's office, deciding, is there probable cause? Is there enough evidence? Is there enough proof to go forward with the criminal prosecution? So there's three right there. And the preliminary hearing could say, no, the judge could say, I don't see it, there's not enough. Drop the case, dismiss the charges. Even though the police thought there was enough, the district attorney thought there was enough, the judge can say no. But we're still not done. Your next step in the process is a grand jury. This is not a trial. This is not a jury trial or jurors on a trial. It says it's a group of citizens who meet to investigate charges coming from preliminary hearings. So if the judge says, yes, I think there is probable cause to go forward with a prosecution, next we're going to get, and I believe it's 16 to 23 people, regular people, citizens, teachers, plumbers, electricians, what have you. These are people, just regular people. They have no criminal justice background, no expertise in the law whatsoever, but they get a jury summons in the mail, just like you do for jury trials, except this isn't a trial. This is just it's just a step in the investigation, in the process. So these 16 to 23 people, they come to, usually it's the courthouse, and it's not even in a courtroom, it's in a conference room, just a regular big room. They all sit around a big conference table, and the prosecutor will be there with some witnesses. And the defendant doesn't have to be there because this isn't a trial and nobody is going to argue against the evidence. It's the prosecutor presents the evidence that they have and asks the grand jury, what do you think? Do you think based on this evidence there's enough to go forward with a trial, a prosecution? And if they say yes, they return an indictment, which is it's both a piece of paper and an action verb. You indict the criminal, the suspect, the defendant, you indict them, and you fill out a piece of paper called an indictment. If the grand jury says no, and I'm going to give you a very famous case in a second here, and this does happen, where the police thought they had enough, the prosecutor thought they had enough, the judge thought that they had enough, and yet the grand jury said, nope, I don't see it. I don't see enough evidence here. So the case can be stopped in the process at that point if they say no. And if they say no, it's called a no bill. So I'm just giving you a little extra information here. But let me talk about a very famous case. JonBenet Ramsey was a little girl, 5 years old, I believe she was 5, in Boulder, Colorado. And she was horrifically murdered Christmas night many years ago. And I don't want to go into the whole case with this video because we're here to talk about our vocabulary words. But long story short, the parents became suspects in her murder. And it was a tough case because there was a lot of evidence pointing to them, and there was a lot of evidence not pointing to them. And the police and the prosecutor thought that they had enough, but they brought it to a grand jury, and the grand jury said, "No, you don't have enough, not yet." And you can actually bring a case, the same case, to a grand jury more than once. They can tell you, these citizens can say, I'd like to see more evidence in this area or more information about that. Can you go find that stuff? And maybe they can and maybe they can't. As it turned out, years and years went by and they worked on this case and they never could bring enough to get that indictment. So we can talk more about that case at another time. But that is just another step. And so if the grand jury indicts, then we go to a jury trial. And a jury trial is 12 jurors, 3 alternates, and the prosecutor must prove his case beyond a reasonable doubt. Beyond a reasonable doubt. That's the standard for a guilty verdict in a criminal trial. And the jury vote, has to be unanimous. All 12. Not majority, not 11-1, or any combination. It has to be all 12 say yes, guilty. Otherwise, hung jury, not guilty. And we'll get into more of that in our courts and law unit. So, and sometimes I like to give you guys little tricks. I mean, I really do want you to remember the word and what it means. But for a vocabulary quiz that I know you want to do well on, sometimes you can come up with little tricks or little games to memorize which word goes with which definition. So let's see. I mean, bail and preliminary hearing, I don't think that those are too difficult. But with grand jury, so jury is a group of citizens, and that group of citizens, jury. And you can't, you've got the term preliminary hearing right here, so that can't be that one because it's in this definition. Our next word is information. Information. I know you've heard that word before, but in this context, it's actually a document. It's a piece of paper. And it outlines the formal charges against a suspect, the laws that have been violated, and the evidence to support the charges. So I think of this word and I think, what is all of the information about this case and this defendant and what laws did they break and what evidence do they have, etc. So this is just, like I said, a document that goes to court. And I believe it's read, right here, your next word is arraignment. So when you get arrested and charged by the police, the next step is to be brought to court and to be arraigned in front of the judge. So the definition is it's a pre-trial stage to hear the information or indictment and allow a plea. And I'll just pause here. An information is usually used for lower level crimes like misdemeanors, whereas felonies, you're going to have a grand jury indictment on felonies, not for misdemeanors. Information would be more for the misdemeanors. So information and arraignment go together. Arraignment is like you're physically brought to the court and told what your charges are, and you're asked, how do you plead, guilty or not guilty? Most people say not guilty because they're going to go talk to a lawyer and figure out what they should do next. But that document, that information goes with the arraignment. So it's what has all that information listed on it about this case. Okay. Plea bargaining, and I'm sure you heard that word before. Plea bargaining is the practice whereby a specific sentence is imposed if the accused pleads guilty to an agreed upon charge or charges instead of going to trial. And I know that your textbook had several pages discussing plea bargaining and why we have it and why we do it. And the fact of the matter is, there's a lot of reasons that we do it. But I started to say the fact of the matter is we have so many criminal cases that we could not possibly take every single one to trial, because there isn't enough time in the world. Like we would still, it'd be 500 years from now and we'd still be trying the cases that we have today. That's how many cases there are. And, going to a jury trial takes a long time, and there's a lot that goes into it, and there's a lot of money involved. So that's one reason we like to offer plea bargains. We offer plea bargains when we think maybe we're not going to get a conviction, that it's better to get something than nothing. Or conversely, it works for the defendant too. The defendant maybe is going to be told by his lawyer, you're absolutely going to be convicted if you take this to trial. They have so much evidence against you. And if you get convicted, you're looking at 25 to life. So my advice is take the plea bargain that the prosecutor's offering. So maybe the prosecutor's offering, a 10 to 15 year deal. The defendant is going to think that's a good deal. I'd rather take the 10 to 15 than 25 to life. So it can go either way. Plea bargaining benefits the defendant, it benefits the state, both. So your next word is bench trial. And it says it's a trial before a judge without a jury. So we do have jury trials, but you don't have to have a jury trial. You can have a bench trial if you prefer. Typically, bench trials are used for traffic infractions and misdemeanors. But you could even request a bench trial for a felony case where you don't want a jury of 12 people. You want that one person, the judge, to decide guilty or innocent. And we're going to talk about that more in class, but something to think about. Why? Why do you think a defendant would choose to have their fate decided by one individual as opposed to 12 who have to be unanimous? So, because that seems to be risky. And so you've got the word trial, plea, bargain, you've got plead, right in the definition here. And our last few words. So probation and parole actually are words that we talk about a lot in corrections. These are typical, parole for sure is punishment after you've been convicted, and probation really as well, although probation does a lot of different things. So you've been arrested, you've either pled guilty or were found guilty, and then you were punished, and your punishment could be probation, or you were sentenced to prison, and they let you out early on parole supervision. So let's talk about the actual definition in your book. So probation is a sentence in which the offender, rather than being incarcerated, is retained in the community under the supervision of a probation agency. So in this context, they're only speaking of probation as a punishment. Probation does, like, as I mentioned, a few other things as well. We'll get into that when we get into corrections. But right now, you have been found guilty or you pled guilty and you're being punished, and your punishment is probation. So this is more typical for your lower level offenses or your non-violent offenses. And, you know, you're in the community, which means you can go to work, you can go to school, you can continue to be a productive member of society. And you'll be supervised by a probation officer. Parole is the conditional release of prisoners before they have served their full sentences. So this is prison. When you are sentenced to prison, not jail, they are different, you may get parole released, early release for good time and things like that. So that's parole. And then your final word here is system. It's a smoothly operating set of arrangements and institutions directed toward the achievement of common goals. I don't really know what to say about this. There's not much to say. I know that your book, you know, it's kind of funny because we call it the criminal justice system. And according to this definition, the system would be a smoothly operating set of arrangements. But your book made the point that our system, criminal justice system, is often not smooth, not well connected and organized, because we have so many different, you know, rules and laws and states and offices and entities, and everybody kind of does things a little bit different, and we need this office to talk to this office, and, you know, sometimes they do and sometimes they don't, and things can get really I don't know what the word is, messed up. So you would not call that a smooth operating set of arrangements. So it's just the point that we call it the criminal justice system, but often there's just a lot of stops and starts. So that's it. Those are your words, guys. I hope this was helpful. Okay, bye.